Welcome back to Congress Unpacked, the place where I break down the wildest moments on Capitol Hill so you don't have to. Today let's talk about Senator John Kennedy's relentless grilling of judicial nominees for the U.S. District Court of North Carolina. If you think confirmation hearings are dull, Kennedy is here to prove you wrong. First up, Kennedy went straight for a real-world dilemma. He asked, imagine a printing shop with an employee who arrives for work in a burqa. The owner isn't happy, fires her, and blames it on what customers might think. What does the law say? The nominee, Matthew Orso, pointed to Title VII of the Civil Rights Act, no job discrimination based on religion, period. But Kennedy didn't let up. What if it's about safety? Matthew Orso admitted. That's a whole new layer. Safety can matter, but the law demands real evidence, not just opinions.
Thank you, Mr. Chairman. I'm sorry, I can't see that far.
Bragdon, me?
Who wants to volunteer?
Senator, I would be happy to
Let's just
go
start in the
first.
middle and we'll work to the end. Tell Mr. Orso.
Orso, yes. Thank
Orso,
you,
I'm
Senator.
sorry. I really can't. I guess I need to get new glasses. Mr. Orso, let's suppose, imagine this situation. Small printing company, they manufacture envelopes, stationery like that sort of thing. 20 employees, small operation. They take custom orders, go in the back, print the stuff. They wear uniforms because the owner wants to promote his company with the company logo. Employee shows up one day in uniform, but she's wearing a burqa. And the owner says, you can't wear a burqa here. And the employee says, yes, I can. And the owner says, you're fired. Tell me how you'd analyze that case, what questions you need to know, who would win, who would lose, according to Supreme Court precedent.
Sure. I would likely look first to Title VII of the Civil Rights Act of 1964, since
That's
it's
correct.
an employment case.
And what's Title VII say?
It says that a person cannot be discriminated against in employment on the basis of race, color, national origin, religion,
Right.
gender. And then I would apply the facts of that case, pursuant to
What
any-
facts would you have to know?
I'd have to know if the wearing of that burqa was indicative of any potential religious, closely, sincerely held religious belief. And then if so, would analyze it from there.
What if the employer said, my customers won't like it? Is that a justification?
I don't believe that would be sufficient justification to discriminate against someone based on religious belief. I think you'd have to take into account whether the employer is providing any type of accommodation that allows for that person to.
What if
to
the
work
small business owner said, it's dangerous? The employee might get the burqa caught in the manufacturing apparatus.
I think I would have to look at the case law if there's anything similar on that, but my instinct is that, in terms of protecting the safety of employees is a valid concern of an employer.
Then Kennedy switched things up. He hit another nominee with a question about supplemental jurisdiction, basically when federal courts can hear related state claims. The second nominee, David Bragdon, stumbled, admitting it wasn't something they dealt with often. Kennedy, never one to let a shaky answer slide, got a better explanation from another judge on the panel. It was a lesson. You can't.
Okay, fair enough. David, I really
Bragdon.
can't see. I need to do
It's
something. but-
Mr. Bragdon. David
Bragdon.
Bragdon, thank you.
Mr. Bragdon, tell me about supplemental jurisdiction.
Supplemental jurisdiction, I am having trouble remembering that term because it does not come up in criminal practice very much, but I believe
It's
it's
going to come up in
jurisdiction-
federal district court
Absolutely.
every other Thursday.
And I will certainly carefully research any issue that were to come before me if I'm
It used to be
confirmed.
called pendant jurisdiction. Does that help?
But I think it's jurisdiction that builds on jurisdiction. I'm thinking it builds on jurisdiction of another party who's already properly before the court. But I don't specifically remember Senator Kennedy.
Okay. Do you know?
Senator, I would say that that is my understanding as well, and I don't have too much to add in my years as an AUSA. I haven't been working on that recently.
Who knows the answer? What's your name?
This is Judge Rodriguez, and so I am a sitting U.S. Magistrate Judge right now, so I think that I'll step in for the panel. There was a recent Supreme Court case on this. So supplemental jurisdiction is when the court would have original jurisdiction over some sort of federal question, but then there is a state question, and so that's where the court can exercise its discretion over supplemental jurisdiction. A lot of times where that comes up is if something gets, the court could get divested of its jurisdiction if a plaintiff dismissed everything, all of the federal claims. And so it goes back to a jurisdiction issue, and that's what you would be normally looking at.
Okay.
Can't fake it in front of Kennedy. Next, Kennedy tossed out a Constitution pop quiz. How do you amend it? Mr. Orso nailed it. 2/3 of Congress or 2/3 of state legislatures plus ratification by the states. Quick and clean. Kennedy barely blinked. He kept the pressure on with questions about injunctions. What's the difference between preliminary and permanent? Mr. Bragdon explained. Preliminary is about stopping harm before a full win. Permanent means you've already won on the facts. Kennedy summed it up. One is about likelihood, the other is about proof. Finally, he wrapped up with a class action test. Lindsay Ann Freeman explained Rule 23. A few plaintiffs stand in for many, but only if they meet strict requirements. Kennedy listened, nodded, and moved on.
Let me go back to Mr. Orso. How do you amend the Constitution?
I think you'd look to, Senator, I think you'd look to Article 5 of the Constitution and follow the instructions for 2/3 of the legislature or 2/3 of the states.
Okay, fair enough. Let me move to the gentleman to your right. What's the difference between a preliminary and a permanent injunction, and how you decide them, Counselor?
A preliminary injunction, well, let me start with a permanent injunction would be a final judgment in the case that occurs after the completion of all the litigation.
What do you have to let's start with the preliminary. What do you have to prove to
Sure.
to
For
the
a
judge?
preliminary injunction, there's several standards the court looks at. You're looking at irreparable harm. You're looking at the likelihood of success in the merits in the ultimate case as it goes through court. You're looking at balancing the equities of the parties. So those are some of the factors the court considers and whether to grant that. And it's essentially, the idea is, can you keep things in place while the litigation is pending?
What factors do you look at for a permanent injunction?
Well, the permanent injunction would depend on the relevant law or action that's being considered.
Yeah, but what factors do you look at for a permanent injunction?
So for a permanent injunction,
You
I
look at
think
the
that
same
that-
factors, don't you?
I think that, in my mind, a permanent injunction depends on the underlying statute or relief that you're taking, and it can vary based on the kind of case.
Well, in a
that's
preliminary
pending.
injunction, you're asking, is the plaintiff or the movement likely to succeed on the merits?
And
In
so-
a permanent injunction, you're asking, has the party succeeded on the merits?
Correct. My only point is what the merits are is going to vary based on the kind of case.
Fair enough. Counselor, tell me about class actions. What are they, and what are the elements of you have to prove?
Senator, I believe you're referring to Rule 23. So in order to have a class action, you're allowing one plaintiff or just a few plaintiffs to stand in for a class of a larger number of individuals. To bring that class, you have to meet the factors that are set out, the elements that are set out in Rule 23. So we're looking at numerosity, typicality, representation, numerosity, commonality, I believe, but those are some of the factors.
So what's the takeaway? Kennedy's questioning proves these hearings are a pressure cooker, and sometimes even smart nominees sweat. Now tell me in the comments, is sharp recall everything, or is judgment more important for a judge? Don't forget to like, subscribe, and share. This is Congress Unpacked. Stay informed, stay critical, and I'll see you next time.